record. Okay, we're on the record calling docket number 21-UST-EA-02, Department of Health of the State of Hawaii versus Respondent, United States Department of the Navy. This is a continued evidentiary hearing on the merits and closing arguments. May I please have appearances of counsel? Let's go in order. Mr. Hargrove.
Good morning. This is Wade Hargrove, Deputy Attorney General for the Department of Health.
Good morning. Ms. Gannon.
Good morning, Hearing Officer Day and Council. My name is Ella Foley-Gannon. I'm with Morgan, Lewis & Bacchius. I have my colleague here, David Brown, also of Morgan Lewis, and Jeff Lau of the City and County of Honolulu. Also in the room with us here physically is Uge Moman, also from Morgan Lewis, and we represent the Board of Water Supply.
Thank you very much. Now, Mr. Henkin.
Good morning. My name is David Henkin. I'm an attorney with Earth Justice, and we represent Sierra Club.
And I did forget to mention that Erwin Kawada, our client representative of the BWS, is also in the room.
The figurative room.
The virtual room, right.
Mr. Jensen.
Good morning. My name is Greg Jensen. With me in the room is Dave Fitzpatrick, and with us virtually are Marnie Riddle and John McKay, and we represent the Department of the Navy in this matter. Thank you.
Okay, just we're going to do just the final housekeeping matters regarding exhibits. Since yesterday, I believe now we have exhibits filed that were supplements to the record. One from Sierra Club, that was exhibits. Let's see here. Just say it for the record. Exhibit S30 or S40. We had, and that's been uploaded to the database with an amended exhibit list. We have with BWS, let's see here. So 4 exhibits, and this would be, I believe, you correct me if I'm wrong, this is B422, B423, B424, and what is the 4th one?
B361.
B361. And these have been uploaded into the database?
That's correct.
Okay, and we have an amended, updated exhibit list. And then just before we got on, we received an amended exhibit list from the Navy with exhibit N-7N added to the record. And I believe that has been uploaded, correct?
That is correct.
Okay. Is there any other exhibit that needs to be added this time besides the motion to admit exhibits that we had that was just filed this morning?
Not from the board.
Not from Sierra Club. I should mention that Sierra Club representative Wayne Tanaka has just entered the virtual room.
Okay. Thank you. Welcome. Welcome, Mr. Tanaka. Okay. Seeing none, let's just move on quickly to the motion to admit exhibits that was filed this morning by the Navy. This is exhibits N-70 and N-7P. This is a request to supplement. I'll just go around. Mr. Hargrove, any objection?
No objection. Thank you.
Ms. Gannon?
No objection.
Mr. Henkin?
We're deeply concerned that we did not have the opportunity to see these exhibits during yesterday's proceedings, that we were deprived of the opportunity to cross-examine. Just wanted to say that for the record. Our position is that the truth is on our side in this proceeding, and so if these are materials that the Navy wants to present, then we have no objection. So
noted. Without objection, these are admitted into evidence. This is exhibits N-70 and N-7P. The Navy can, oh, pardon me, Mr. Oh, Mr. Jensen, do you have something to say? I'm sorry.
Yes, I'd just like to proffer for the record and the viewing public that these two exhibits consist of a media release from the Department of the Navy dated November 29th, 2021, informing the public of the groundwater contaminant or of the potential for water contamination in the drinking water, and subsequently a newspaper article or an article from the Hawaii Public Radio's website dated November 30th, advising the public also with regard to this media release. And it goes to counter the claim that the Navy did not notify the public with regard to the contamination issue until the 3rd of December. Thank you.
With due respect, that's a mischaracterization of the media release. The media release states that guidance for only residents of the Joint Base Pearl Harbor Hickam military housing, so not AMR or anyone else, those people were advised by the Navy that if they smell fuel in their water, maybe you don't want to ingest it. That's N-7O. So no, it's not a general notification of the public. It's not a statement that things aren't safe to drink. It's if you smell fuel, don't drink it if you live at Joint Base Pearl Harbor Hickam. N-7P is a news report that accurately says that the Navy made that recommendation. It says U.S. Navy recommended Monday night that Joint Base Pearl Harbor Hickam military housing residents avoid ingestion of their potable water as a cautionary measure, quote, if chemical or petroleum odors are present, end quote. The news report is also accurate, saying, quote, the State Department of Health went a step further Monday and recommended that all, underscore all, Navy water system users avoid using the water for drinking, cooking, or oral hygiene. That is not with respect to if you smell anything, because if you smell anything, they also said, if you detect a fuel odor from your water, you should avoid using the water for drinking, cooking, bathing, dishwashing, laundry, or oral hygiene. That's what the Department of Health said. And it also correctly notes that the commander of Joint Base Pearl Harbor Hickam sent a message to residents in the military housing communities on Monday, reaffirming their commitment to investigating the complaints. And then Captain Eric Spitzer said that he and his staff were drinking the water. Some staff members also live in the housing, were using the water as well. So that's the information that the Navy provided to the public on the 29th, which is we're drinking it. If you smell fuel, don't drink it. Or think about not drinking it.
Yeah, of course, Mr. Jensen. So but after Mr. Jensen, after you comment, we're just going to close it right there. Mr. Jensen, you may respond.
I would just like to point out that with regard to the newspaper article, the Navy has no control over what the news system publishes. The important point is with regard to our media release, and our media release says, not maybe, as Mr. Hickam would claim, it does say in particular, if chemical or petroleum odors are present, recommend avoiding ingestion as a cautionary measure. Thank you.
And apparently you have no control over the commander of Joint Base Pearl Harbor Hickam telling people I'm drinking it, don't worry about it.
I'm out. That's it. Okay. We'll save this for argument. The documents speak for themselves and you can argue it at the appropriate time.
The public probably won't have access to these documents. And so Mr. Jensen wanted to put on the record what they said, and so did I.
Okay. I believe that's been done.
Thank you.
So with respect to just confirm on the record, N-7O and N-7P are admitted into evidence without objection. Those can be uploaded immediately and an amended exhibit list filed. With that understanding, I believe that is the close of all pending requests. Mr. Hargrove, would you like anything to add anything before we close the trial record?
Would not, thank you.
Ms. Gannon?
Nothing further to add.
Mr. Henkin?
Nothing further.
Mr. Jensen?
Nothing further.
Okay. With that, the trial record will be closed. As soon as Mr. Jensen informs us that the documents have been uploaded, I will work with our DOH staff to basically close the joint database that we've been using so that it's not subject to amendment anymore. And then we will proceed. With respect to the arguments today, we have
one question. Sorry, here, just a technical issue. Will the parties still be able to access it to
Oh, yes.
download?
Yeah, so basically it'll just prohibit uploading.
Wonderful. Thank you very much.
With respect to today, we have 15 minutes apiece for closing arguments. The order of presentation is the reverse order of the evidentiary presentation from yesterday. That means it would be first the Navy, second Sierra Club, third Board of Water Supply, and fourth the Department of Health. I would like, if possible, just to make sure that the hearings officer has what I believe to be the correct framework of what is at issue in this case. I'll just briefly state my understanding of the issues, just basically the skeletal issues in this case. And you can tell me if I'm correct or incorrect, but I think that would be helpful to me in this argument. So basically, the hearings officer views the emergency order as borne out in the evidentiary hearing as having essentially two separate, albeit related emergencies. The first is the release on November 20th, 2021, and the ongoing response. This concerns, in the emergency order, there are 5 enumerated orders, or I'll just call them the enumerated orders. This first emergency would concern 1, 2, and potentially 5. 1 concerns the immediate suspension of operations primarily. The second concerns the installation of a drinking water treatment system or systems. And then the fifth is basically about taking corrective actions. The second alleged emergency is broader and concerns the systemic problems with the continuing operation of the Red Hill bulk fuel storage tank at the current time at any fashion. And this is all 20 tanks. And this primarily concerns emergency orders enumerated as 3 and 4, which primarily concern the defueling of 20 bulk fuel storage tanks. And again, order 5 could relate to both. The first emergency or the second alleged emergency. I believe that my take on it is they seem to be separate but related. I would like a statement from each party whether they agree with that characterization or not. And with that, Mr. Jensen, if you'd like to proceed.
Yes, sir. Good morning, hearing officer Day, council, and everyone watching. To a certain extent, the evidence presented and the arguments made by the 4 parties to this hearing are like 2 ships passing in the night. On the one hand, you have Department of Health, Board of Water Supply, and Sierra Club, and they're focused on the what if this and what if that. And on the other hand, you have the Department of the Navy, and we're focused on what happened. How did the release happen? What did we do to isolate the contamination? What did we do to take care of our people? And what are we doing to clean up the mess? An emergency order must focus on what's happening now or just about to happen. What is the imminent peril and how to handle it? Today, on December 21st, here is where we are. The emergency was realized. The Navy immediately responded by doing all things that you've heard. And because of that, there is nothing happening now or just about to happen that an emergency order needs to deal with. The last release from an underground storage tank was in 2014. And in 2015, the Department of Health, the EPA, the DLA, and the Navy mutually agreed on an AOC, an administrative order on consent, to address that release and to work cooperatively to protect drinking water, the human health, and the environment. The May and November releases were not from a tank farm or were not from a tank. They were from pipes. And there is good cause to believe, as you heard yesterday, that the 2 releases are related because the pipe in the November release was an AFFF pipe, a fire suppression pipe, which shouldn't have been holding fuel, had to have gotten the fuel from somewhere, and most probably got the fuel during the May release. That's under investigation, but that's what we know now. My point is that these releases or indeed one release, the May release that ended up in the pipe and then subsequently was discharged from the pipe, the AFFF pipe, do not support a what if tank release. There are a lot of tools in the Department of Health's Board of Water Supplies and Sierra Club's toolbox to address the what if. The AOC is one, and the Department of Health agreed to it. Navy's role, as you've heard yesterday, is to produce deliverables. And we've done that. For example, the groundwater model was submitted in March of 2020. They've spent a year and a half talking about it and thinking about it. We've asked for formal comments on it, which they have not yet sent. They haven't engaged in the process they've agreed to. And now the Department of Health wants to use this process, the AOC itself, and their own dereliction within it as a basis for the emergency order. The permitting process is another regulatory tool, and Board of Water Supply, Sierra Club, and Department of Health, through the Environmental Health Agency, brought a contested case hearing over whether a permit should issue. The administrative order of consent is still in effect. It is working. Department of Health and the Navy remain engaged in that process, and 6 years later, there have been no further tank releases. The best evidence that our improvements are working. The permitting process is also still underway, and the Navy, Department of Health, Board of Water Supply, and Sierra Club are still very much engaged in it. Best evidence of that, the other three parties have moved to reopen the hearing to present the evidence that you heard yesterday, and undoubtedly a great deal more, given that that contested case hearing will not be confined to the one day that you had from the Department of Health to consider the matter. But let's take a moment and address the what if. Okay, let's talk about the what if. Red Hill, as you heard yesterday, the underground storage tank system has a series of interlocking safety systems to prevent releases, and if there is a release, to detect them. And that second part is important. Tank tightness testing, you heard about that. It's our leak detection method. We conduct it twice a year, even though the regulations only say we have to do it once a year. It takes days to conduct. It's performed by professional engineers, not the Navy, contracted professional engineers. And we've done it, and all active tanks have passed the tank tightness testing system. Term is the Tank Inspection, Repair, and Maintenance Program. It's the industry standard approved by the American Petroleum Institute, and includes the non-destructive examination that you heard all about. It is also Department of Health approved. Automated fuel handling equipment. You heard about that from Captain Meyer. These are the fuel monitoring systems that gauge the fuel, work the processes. It works. It works in September in that incident that has been reported where there was no fuel release, but there was a problem with the system. It worked. Groundwater monitoring. You heard evidence on that, and you saw graphics on that. We prior to 2014 didn't have a lot of groundwater monitoring stations. We now have more than 20, and we're working to get more. Soil vapor monitoring. You heard about that too in the Department of Health testimony. They're early warning sentinels that something has gone wrong, that there's a problem in the tanks potentially, and that there's a leak. They're counters. These soil vapor monitoring systems are counters to any claim that a tank could be leaking a small amount and we would never know. And on these 5 systems, it's important for the hearing officer to understand, I think, that the only measure that's in the Department of Health underground storage tank regulations is the tank tightness testing measure. And that's once a year. The other systems, the other things I've just talked about go above and beyond. Why does the Navy do it? Well, it's the right thing to do, obviously, but also because it was agreed to by Department of Health, EPA, and DLA. And it was designed to account for any special risk that might be present in the Red Hill underground storage tank system. So, and I'm going to get to your point now, sir, with regard to what does the emergency order offer and what should we, how should we think of it? Okay, we have an emergency order here. I'm going to talk about justification first, and then I'm going to talk about the directives. So we have an emergency order here without proper justification. First, the first justification cited to the emergency order are a number of alleged failings with regard to the AOC deliverables. We already talked about that. This justification is not in the form of an emergency, let alone imminent peril. There are disagreements on analysis, disagreements on experts. There's a resolution process in the AOC with regard to these disagreements on deliverables. The Department of Health has never exercised it. They can't, honestly, because they haven't even gone through the process of working it out with the Navy yet. We ask them for documents and they don't give it to us. So how can they move forward with their dispute resolution process there? That's one question, kind of irrelevant to this hearing. More relevant, how can they use that as a basis to claim that that is proper justification for an emergency order? It's just not. Second, the order lists what they allege are the 5 releases. The first, in 2014, as I already told you, was the impetus behind the AOC. A release in 2014 cannot justify an imminent peril determination in 2021, especially when the parties decided, including the EPA and DOH, decided that the proper vehicle to address that release is an administrative order on consent, which is what we all agreed to do. So that one's out. 2 additional releases, Hotel Pier and Kilo Pier. You didn't hear a lot about these, probably because all the parties recognize they're not really relevant, but I'll give you some information that you'll be able to see in the record and in our briefs, okay? First, they're pipe vents. They're not tank vents. Down at the harbor, 4 miles away, they're not up here, okay? And they're adjacent to surface waters, not the groundwater, all right? So those are important points. Plus, and significantly, those issues were both addressed on a practical and regulatory matter level. So they've been addressed, they've been resolved, and they were resolved consistent with what the regulators told us to do. So no one is at risk. And then finally, you have the May and November releases that are most probably connected, as I've already discussed. Importantly, the contamination source was isolated, people were protected, and cleanup is ongoing. Okay. So third, the order cites the contamination at Red Hill, suggests the contamination may have been a result of the May and November releases, and argues that Red Hill lacks infrastructure to deal with this. Okay, got that. We all agree, okay? There was probably a connection between the May and November release. And we have very good reason to think that the November release was the cause of the contamination to Red Hill. But the Red Hill shaft is closed down and will not reopen until water meets EPA and DOH requirements. Okay, that's important, number one. And on infrastructure, DOH wants drinking water treatment systems. The Navy wants drinking water treatment systems. We've already went out and purchased large GACs and are using them right now to clean out the distribution system of the Red Hill well. And we have even larger GACs, multi-million dollars, $20 million worth of GACs on their way that we're going to apply to the wellhead once we get a permit from Department of Health, because we would not do that without getting the permit from them, and use that to flush the water, okay, out of the well, treat it, okay, and put it back into the system. So those are the justifications. I just ran through all of them with you, and none of them support an emergency order. Let's talk about the directives. Directive 1, that the Navy immediately suspend operations at the bulk fuel storage tank. Well, as you know, the Navy's already suspended operations at Red Hill, and the Navy's suspension will continue at a minimum until the investigation into what happened at the Red Hill shaft and how it was contaminated is determined. And that makes sense, okay? A forever suspension is not appropriate. Find out what happened, you make sure the processes you have in place address it, and then you move forward. That's not what the emergency order does. But importantly, with the suspension, there is no emergent need to take any other action or to take another type of expansion to protect human health and the environment. Directive 2, that the Navy take immediate steps to install a drinking water system or systems at the Red Hill shaft. I've already talked about that, so I won't, we're doing it, all right? And that's important. Another important point is, just because a provision within the emergency order is a good idea doesn't mean that it substantiates or it validates the emergency order itself. Okay. And I think that's important. Directive 3, submit a work plan and implementation schedule to safely defuel the bulk fuel storage tanks. Well, the Navy's order says instead that the Navy will develop a work plan to conduct necessary repairs. Look, we have it right. Department of Health has the cart before the horse. They have it wrong. The Department of Health has presumed defueling is necessary and worked backwards to get to defueling. Okay. We instead are directing the same type of analysis be done. And however that analysis comes out, we will do the things required from that analysis. Secretary Balaki said on the stand yesterday, if that thing includes defueling one or more tanks, we will do it. So again, we're not putting the cart before the horse. We're working as we should chronologically moving forward. Directive 4, defuel the bulk fuel storage tanks at the facility. So again, the last release from an underground storage tank at Red Hill was in 2014. And we all know that it was caused by contractor error. The Navy has a robust program to ensure that the continuation of the integrity of the tanks. The recent releases, the ones that everyone complains about, are from pipes, not tanks. And one of them was from an AFFF pipe, which isn't even a fuel pipe. Assuming there is imminent peril, therefore, which there is not, an appropriate order would address deficiencies in the pipes, not the tanks. Directive 4. I'm sorry, I just discussed Directive 4. Directive 5. Submit a work plan to determine deficiencies that may impact the environment and develop correct recommendations for corrective action. The SECNAV memo contains nearly identical language. And again, I'll make the point. The mere fact that some of the emergency orders provisions are good ideas is not the legal standard for whether an emergency order is appropriate. The stakes are high. Secretary Balaki has told you that the Red Hill bulk fuel storage facility is a critical national security asset. The burden is on the Department of Health, and they can't meet the emergency order standard. On the medical piece, you heard from Dr. McGinnis that based on what he knows, he does not anticipate any long-term health impacts. If that's not good enough for you, Dr. Felton, Department of Health's toxicologist, said the same thing. And she shared that both with you yesterday at the hearing and in public forum, at least 2 Fridays ago. And their opinion is based on medical and toxicological expertise and direct knowledge of both patient dose and exposure. And while Mr. Brown attempted to cross Dr. McGinnis with regard to textbooks, it's important to understand that he has the experience from the last 20 days, 25 days, to come and the expertise to come to his opinion. And I would note that Mr. Brown did not choose to cross-examine Dr. Felton with regard to her position. The Navy has isolated the Red Hill shaft and suspended operations at the underground storage tank facility and is taking
15 minutes has elapsed.
You may sum up.
Okay. It's taking care of people in extraordinary ways. The Navy is testing constantly and continues to confirm that the only well impacted is the Red Hill well. In addition, we're purchasing clean water or drinking water systems, treatment systems. Yes, pumping draws contamination to the wellhead. Sherry Ng told you that yesterday on Direct. And that's why we have 2 larger GAC systems, which are expected to be here within roughly 2 weeks, and for which we're seeking a permit from Department of Health that will flush and treat the Red Hill. That is so important. Once again, the Navy is not saying that the contamination at the Red Hill shaft was not significant. It was. And the Navy and I personally am deeply sorry for the impact of that contamination on the lives and the people of Oahu. What we are saying is that our efforts to address this issue have mitigated the immediate impacts and kept any further significant impacts from happening. No one is at actual risk of harm today, and there is no justification for any provision of this order. Subject to your question, sir. Thank you very much.
Very much. For everybody else's knowledge, the same ability to summate their argument that was granted to Mr. Jensen will be granted to everybody else as well. in like form. Mr. Henkin.
Good morning, Hearing Officer Day, Council, members of the public. Sierra Club is shocked at the Navy trying to lay the blame for its own leaks and spills that have poisoned our water supply, trying to lay that on the Department of Health. Sierra Club intervened in this case because we were concerned that the Department of Health might not stick to its guns as far as implementing the emergency order. But we have never suggested that the responsibility for keeping fuel in the tanks, fuel in the pipes, lies squarely on the Navy. So I don't know. I did not expect to hear that. In response, hearings officer, to your initial question, we agree completely with your characterization of the two different elements of the emergency order. You've got a question whether there was an emergency on November 20th when 14,000 gallons of mixed fuel and water entered the drinking water system of the Navy, poisoning the well literally for nearly 100,000 military service members and their families. And all of the evidence we've heard from everyone who wasn't coached by counsel admitted that it was a crisis. That was we heard from Captain McGinnis that it was a public health crisis. We heard from Captain Meyer that it was a crisis. We heard, so there's no question but that emergency exists. And with respect to those particular provisions, provisions 1, 2, and 5 of the emergency order, the Navy basically has conceded that there was an emergency. These things needed to be done. And I'll get into this a little bit later, but rather than abide by the December 6th, 2021 emergency order and not contest at least those provisions, the Navy decided to contest it. And then the Secretary of the Navy decided to issue his own order the next day on December the 7th, and that's Exhibit N-1C, and say, we're going to do all those things. And now Mr. Jensen and the Navy tell you, because we're doing those things, there's no longer an emergency. They should have just abided by the order. But ultimately, the other issue that came up and what the Navy had to say is, Mr. Jensen kept saying, it's not the tanks, it's the pipes. Well, first of all, the emergency order under HRS 342L has to do with the entire underground storage tank system, the entire facility, not just the tanks, but also the pipes. It provides cold comfort to the public that the Navy apparently doesn't even know where the 14,000 gallons of fuel really came from. They suspect that it came from the from the May 6th release. Now, remember, back in May 6th and following, they did an investigation. They determined there was a release of 1,600 gallons. They claimed to have accounted for all but 38 of those gallons. They went through that investigation. Now, if Mr. Jensen was correct that they have systems in place to make sure that they can prevent leaks, and then when leaks happen, respond to them properly, this is a vivid illustration that this archaic system that they're trying to operate with over 180 million gallons of fuel perched 100 feet over our sole source aquifer and threatening, catastrophe on the scale of what happened on November the 20th, and frankly, even worse things that in the future. The fact that it came from a pipe and it came from an AFFF pipe, which is not even supposed to have fuel, that doesn't give me, and it shouldn't give you, and it shouldn't give the public any comfort. If they don't know where the fuel is coming from and where it's going to, and we heard from Captain Meyer that maybe there was a release on May the 6th, not of 1,600 gallons, but maybe it was closer to 19,000 gallons. This is the existential threat that we face. And so, really, ultimately, what this case is going to turn on is whether the existential threat to the people of this island posed by the Red Hill facility, not necessarily by individual tanks, but the entire operation, which under the law is regulated as one entity, constitutes an emergency justifying the department's exercise of its, quote, emergency powers, end quote. And I use that term specifically because that is the language of HRS 342L9A. The legislature said these are emergency powers. It defined what an emergency is by saying that these are the powers that you can exercise when the terms of HRS 342L9A apply. So the question is whether this department, the Department of Health, can use these emergency powers to protect the people's constitutional right to a clean and healthy environment and to discharge its duty to protect Oahu's sole source aquifer, which is an irreplaceable public trust resource. Now, there's no issue about the fact this is a federal facility or a military facility or anything like that, because in enacting the Resource Conservation Recovery Act, the federal government expressly waived its sovereign immunity and made all of its facilities, including Red Hill, subject to state regulation of its underground tanks. And again, not just the individual tanks, but the entire system, including these pipes that AFFF pipes and any other pipes that are going to leak oil into the environment, including the ones down by the water, because the water, even though that didn't get into the aquifer, that poisoned Pearl Harbor, which is also a public trust resource. So again, in terms of the department's obligation to protect our ocean, as well as our groundwater, the fact that there have been four releases in this year alone, the May 6th release and the Kilo and Hotel Pier releases, and then this November 20 disaster, res ipsa, the facts speak for themselves. The Navy has absolutely no control over protecting this, the environment from being poisoned and protecting the people of this island from being poisoned. So despite all of this, the Navy tries to avoid its statutory duties, as well as its moral obligation to the people it has sworn to defend against enemies foreign and domestic by trying to exploit perceived legal loopholes. It says that 342L9 does not apply because there is no imminent peril. And it says even if it does apply, the department can't use its statutory authority that the legislature expressly gave it to protect us because the department allegedly tied its own hands in the AOC and is obliged to slog through years of negotiation with the Navy, which, as we well know, the Navy will never agree to do anything that anyone else tells it to do. Witness that they are objecting to paragraphs 1, 2, and 5 of the the emergency order because they didn't say so, but then the next day the Secretary of the Navy ordered it, and now they say it's the thing to do. Footnote: the Secretary of the Navy issued that order on December the 7th, and the terms of the order claim that they're going to keep the Red Hill tanks inoperable until they finish their investigation. However, as Secretary Balaki testified last night, tomorrow the Secretary, or later today the Secretary, could rescind his own order because they want to be in control. They want to decide what they do and when they do it. They don't want the Department of Health, which is the entity that is to protect us and protect our environment, to be in control. Fortunately, none of this is accurate from a legal standpoint, or I might say from a moral standpoint. So first of all, with respect to whether or not there is 342L9 applies, I discussed this in my opening. The statute defines the trigger. What the legislature said is whether the operation of the facility poses, whether it poses imminent peril now or in the future. And the thing that needs to be imminent is peril, risk. It doesn't have to be actuality. You don't need to wait until the oil is poisoning the water to act. In fact, consistent with the precautionary principle and its constitutional duty to protect the public trust, the department has to act now. You can't wait. We heard from Captain Meyer. I asked him, I said, why didn't you stop the May 6th release of whether it's 1,600 or 19,000 gallons? He said, well, we couldn't do that. And now, why didn't they stop the 14,000 gallons from poisoning their own water system? Because they can't. Under their definition of what an imminent peril is, you have to wait till, to use Mr. Jensen's term, the horse is out of the barn. I'm sorry, the horse got off the cart and now it's out of the barn. And try and close the barn horse doors after you've already poisoned the water. That's not what the legislature intended. The legislature made it very clear that the department can and constitutionally must take action if there's imminent peril now or if there will be. So, and even if it, it is undisputed in this case that the Red Hill facility stores over 180 million gallons of jet fuel in ancient tanks that loom a mere 100 feet above the aquifer that EPA has designated as the sole source aquifer for this island. It's undisputed that these tanks and the pipes and the whole facility leaks, and it has poisoned the environment, most notably on November the 20th, but it's done it before. There's all sorts of contaminants in the groundwater, and there's a lot of uncertainty about where things end up. Again, witness the May 6th event, in which we don't really know where the fuel went, how much fuel there was, and now we suspect, because the Navy has no other way to account for 14,000 gallons of fuel somehow entering its water supply system. They say, oh, it must be the May the 6th event, but they don't know. I mean, that's why I was trying to explore that with Captain Meyer. I said, you said there's no connection between what happened on May 6th and the AFFF pipe. And he was like, where else would it come from? Good question. Talk about imminent peril. Talk about a facility that needs to be defueled, not forever, as Mr. Jensen would suggest, but as the emergency order very properly says, it needs to be defueled now because it poses an imminent threat, and it can be refueled when it's safe to do so, Now, Mr. Jensen sort of walk through these various releases. Oh, there was a 2014 and that got resolved. And then you had all these other releases, the May 6th and the Kilo Pier and the November 20th, and we're dealing with it. What the Navy fails to recognize is that the regulation is not of individual releases. That is one thing that can trigger an emergency order, but it's a regulation of the operation of a facility that poses an imminent peril. And there is no dispute here, there should be no dispute, that this facility poses an imminent peril. You have the unrebutted testimony of Professor Lawrence Thomas Ramsey, who described the chilling implications of the aptly named Russian roulette analysis in the Navy's own QRVA. So that document's S26. And that's the one that tells you that the likelihood of a leak of 1,000 to 3,000 or 30,000 gallons in any given year is nearly 28%. In 5 years is over 80%. And in 10 years is 96%. And in 20 years is a near certainty at 99.8%. You have the testimony of Dr. David Norfleet that the Navy's analysis underestimates the risk. It failed to take things into account. And it is undisputed that it's only the first of 4 analyses, because they didn't consider, for example, risk from earthquake, fire, or flooding. The initial analyses will only increase the risk, not decrease the risk. Now, the Navy offered no new expert analysis that takes into account the recent leaks, including the November 20 event. Instead, its lawyers baldly assert the Navy's reduced risk by identifying unspecified measures since they did their risk analysis in 2018. Lawyer statements are no substitute for evidence. In any event, it ignores the facts on the ground. We've had 2 releases of more than 1,000 gallons related to operations at Red Hill in this year alone. The May 6th one of 1,600 gallons, although the working assumption is now that it might have been 19,000 gallons, and the catastrophic release of 14,000 gallons on November 20. That's 2 in 1 year, not 1 every 20 years. So the risk analysis, if anything, underestimates the threat. I'm going to get back to a point I made at the beginning. This is clearly a power struggle. It's a power struggle between the Navy and the Department of Health. The Navy wants to arrogate to itself the sole authority to decide how much protection we can get from being poisoned by its wells. The Navy acknowledged that an emergency existed that necessitated shutting down the Red Hill shaft, that necessitated bringing in these GACs and things to clean out the water system. And well, it should. You heard the chilling testimony from our witnesses who have suffered through the nightmare of the Navy's disaster. But rather than acquiesce in at least those portions of the executive order, they decide to fight. And then they issue an order the next day, the Secretary of Navy's order, that he can rescind at any moment. But that, the evidence you've heard makes it clear that the things that they claim are simply not true. It's not, the nation will not fall if we defuel the Red Hill tanks. The order does not say that the fuel can't be anywhere. It just says it can't be in these leaking tanks over our aquifer. And Secretary Belaki said that if the Navy's analysis says that one or more fuels should be defueled, they're going to do it. Again, if they decide they'll do it, but if the Department of Health, in the exercise of its constitutional and statutory duties, determines the safety of our people require it, they'll fight it to the death. The Navy's actions show that they're more concerned about whatever they consider to be their mission, and I would suggest it should be protecting our health and
15
safety.
minutes has elapsed.
Hagan, you may submit.
Thank you. The Navy has demonstrated through its actions that it will put whatever it considers to be its mission ahead of the interests of the people of Hawaii. It did not warn people after the spill on November 20th. Its belated, half-hearted, and misleading warnings after the Department of Health said don't drink the water, were only reported to the residents of Hickam Pearl Harbor and not the people at AMR who you've heard from who have been poisoned. And they only said don't drink it if you smell the fuel, when we all know, and there's been testimony that still causes harm if you can't smell it. They violated the Department of Health's order. That's our exhibit S40. They decided, okay, we're going to open the fire hydrants and flush our system in violation of Department of Health orders. So they do whatever they want to do. Well, the Department of Health has a mission too. Its mission is to protect the people of Hawaii per statute and its constitutional duties. And so, you know, at the end of the day, their assurances that they can protect us from a future spill give cold comfort when you realize that they have no idea where the 14,000 gallons that poisoned the well on November 20th came from, even after months of investigating the May spill. They couldn't stop the prior releases. The statistical analysis and the risk assessment says it is not a question of whether, it is a question of when there will be another catastrophic spill. Captain Myers told us that it takes days, maybe over a week, to defuel a tank. They can't stop the harm from happening. We need to be proactive. We need to be precautionary. Make no mistake, imminent peril exists. It exists now. And the Department of Health should stick to its guns and hold the Navy to defueling those tanks and not allowing them to be refueled unless and until it is safe for the people of Hawaii. That's the department's obligation. We cannot defer that decision to the Navy, as they argue. Thank you.
Thank you, Mr. Henkin. Ms. Gannon.
Thank you and good morning, Hearing Officer Day, Council, and the public. I'll start off by addressing the questions that you posed to us this morning, because I think that's a good framing of the issues in a good way before we go through the evidence that you've heard. You asked, is it appropriate to divide it into sort of two issues, dealing with the current peril that the people of Oahu are experiencing and looking at the future peril that the people of Oahu experience because of the existence and operation of these worn out tanks. And I think we should start by looking at the authority of the DOH to issue an emergency order to see if that's an appropriate way to approach this situation. And I think all you have to do is look at the language that says that this authority is to address an imminent peril to human health and safety or the environment that is or will be caused by the operation of a underground tank system. So the legislature has already clearly addressed that that's an appropriate way to approach it. You don't have to just address things that are happening today. You don't have to just stop things when leaks have happened or when people are getting sick and animals are dying because they're drinking contaminated water. We don't have to. The legislature wisely, and as it was constitutionally required to do, said, no, we have to prevent these sort of things from happening. And there's no better example as to why that's required than looking at this situation. And I'd start off by saying also that one of the things that the board has been doing ever since the 2014 release, the board, in exercising its public trust responsibility to protect this irreplaceable water resource, took a really hard look at this system. And it took a really hard look at this system because it's, close to 200 million gallons of fuel above a sole source aquifer and 80-year-old tanks, an 80-year-old system. Just looking at that specs makes you think, wow, we really have to look at this carefully to make sure that we're not going to do irreparable damage to our aquifer and lose this irreplaceable source and right of the people to have clean and healthy drinking water. So the board has been working on this and has spent huge amounts of its resources to protect its customers and to carry out its public trust. And what all of that analysis has led us to do is to be ringing the alarm bell for years, saying, everybody, you know what's going to happen? Sometime there's going to be a leak, and it's going to get out, and it's going to get into the water, and it's going to get to the drinking water. That could happen. We got to take actions to stop that. What did everybody say when we said that? The Navy said, no, it couldn't ever happen. Yeah, we've had leaks. Yeah, there's been problems, but we've got systems. And Mr. Jensen just referred to all these systems that are there. But again, just looking at what happened recently, and as Mr. Henkin just pointed out, did those systems stop the recent leaks from happening? Did those systems allow them to track where that fuel was going? Did those systems do what Mr. Jensen called the early warning signs, so we would make sure that nobody in the public was damaged? No. How did we find out that there was fuel in the drinking water? Because people turned on their taps and they smelled it and they tasted it and they saw their dogs getting sick and their children getting rashes on their bodies. That's how we knew it, not by any early warning system that the Navy has been operating. So when we're talking about looking at an imminent future threat and the authority and the need for the department to act, I don't think there's a clearer case. I don't think there could be a clearer case, because we have to be warned. We're lucky that we haven't had a larger release yet. The reason all that evidence about the problems with the tanks and the problems with the way that they inspect and repair them or do not, the problem with what happens with their pipelines, the problems with the way they track the fuel, all of that speaks to the incredible peril, the incredible threat that exists right now today. It's even with the fuel not moving, there is still 187 million gallons of fuel 100 feet above our sole source aquifer. That is peril. That is a reason for the department to act. And if you don't act, what could happen is we're going to have one of those major releases. And when that happens, we're not going to be able to clean it up. We're going to get to a point we can't even safely and quickly clean up these spills, which are much smaller than what the ABS's risk report says could very, very well happen from this facility. That is not a risk that we can afford to take. We can't wait until it's ruined to take an action. And so we applaud, and we applauded the department issuing this order and appropriately saying, we got to do things tomorrow to address the stuff that's in there right now that just happened. And we've got to take action right now to make sure that this imminent threat that is caused by the operation of this facility is addressed. And Mr. Henkin in his opening, and we in our papers have discussed why this authority is appropriate, why it applies to this situation. And we will direct you, Hearing Officer Day, to closely look at those and to closely look at the Navy's explanation for why this doesn't apply. It simply is not a correct reading of the law. It's not a correct representation of the facts, and it's simply wrong. And so in response to your overall questions, we agree with the way that you're approaching it. We agree that those are the measures that address these concerns, and we ask that you do that. We also want to address the Navy's argument that they have made and that they seem to be making throughout the proceeding by their questions and with their witnesses, was that somehow the Department of Health is handcuffed because it entered into an AOC to address the 2014 very serious leak. And that's simply not true. And that's not true from the face of the AOC. They talked about, the dispute resolution proceedings, and yes, those are in there, absolutely. And those do authorize all the parties to exercise those actions. However, importantly, and you'll remember we talked about this, and it's in the AOC itself, which is Exhibit B81 at BWS 008953. It says that the DOH expressly reserves its right to take, direct, or order any and all actions necessary to protect public health, any source of drinking water or the environment, or to prevent, abate, or minimize an actual or threatened release of hazardous substance, pollutants, or contaminants or hazardous or solid waste from the Red Hill facility under, among other things, Hawaii Revised Statute Chapter 34.2L. And again, you're exercising your authority under 34.2L. So their argument that you can only rely on the AOC is simply incorrect. Now let's just walk through, let's take a little bit of time to walk through the evidence that you heard. In my opening argument, I told you that what you were going to hear was that the water has become polluted. Unfortunately, it happened, as we always feared that it would, and that pollutant got into drinking water, and that pollutant has damaged real people on the island, and that it still exists in the drinking water today, in the system today, in the aquifer today, and that the Navy's actions that they've taken, and we applaud them for taking actions to try to protect their service people. They should certainly do that. And we recognize that they're trying. They're absolutely trying. But the problem is they can't do it. Just like we know they don't want to have leaks. They want to keep the fuel in the tanks. They want to be able to use the fuel to service their fleets and for other uses. We're not contesting that. We're not contesting their desire. We're contesting their ability to be able to do that. And that's largely just because these tanks are 80 years old and they don't have the capability to service them. They don't have the capability to keep them running in good order. So that's what we said we were going to show you. And I think that's what we did show you. So we showed you that there's been contamination. We showed you there's been harm. And we showed you that harm is happening right now, and that the harm is going to happen in the future. So just to go through quickly through what you did here, we first heard from the DOH witnesses, and you heard from Noah Klein, and a couple of really important things from her testimony was that she, who's one of the people who helped write these regulations, says that the DOH has this emergency power. She also says that, again, she wrote was largely drafting the underground storage tank regulations that apply to these facilities. She says that the Navy can't comply with them. And it's not that they can't comply with the tank tightness testing. And I think Mr. Jensen seemed to indicate that was really the only thing in the ARs that applied here. There's many, many more requirements that apply to USTs, including that they have to be operated and maintained in a way that prevents leaks for their operational life. We can clearly see they can't do that. She also walked through the corrosion protections measures that are required, and she clearly pointed out they can't meet that. And then we heard from Lene Ichinosubo. I'm sorry if I mispronounced her name. And she, you remember, is the acting chief from the solid and hazardous waste branch. And she told us, they haven't inspected many of these tanks within the 20 years, some of them up to 40 years. And some of them they've recently inspected, but some of those hadn't been inspected for 60 years. And this is according to an industry standard that says that they have to be inspected every 20 years. They simply haven't done it. And they don't seem to be able to do it. We've also heard, she also testified about the impacts to the Navy's drinking well. And that there were hits for TPH that was 350 times higher than safe levels. So these are very significant facts, again, when we're looking at the peril and the damage and the emergency that has and will continue to happen. We also heard from Phoenix Grange, and she was the supervisor from the Hazard Evaluation and Emergency Response Office, you'll recall. And she talked about the problems with with all the information that the Navy doesn't have, with all the things that they haven't done in their groundwater modeling, and how they haven't been responsive to the comments from the Navy. And why was this groundwater modeling so important? So that when there is a spill, when there is a leak, we might have a chance to know where it's going and to be able to address it. We simply don't have that information. So that makes the peril that much higher. That makes the risk that much greater. They simply don't have the information. And finally, we heard from Dr. Diana Felton, and she talked about the really acute and serious health effects that being exposed to petroleum has, and that there have been over 5,000 medical screenings that have happened. And we brought on our witnesses. And as I told you, Mr. Kawada would talk to you about the damage that's happened to the aquifer, and that it's possibly irreparable, and about the impacts that has on the BWS, on its customers, and on the island as a whole. And you also remember that he said that in his 39 years of experience, he had never seen a more imminent peril to drinking water in his entire career. And he told you that, and that was not contested. And then we had Dr. Norfleet, who testified, and he testified about all of the problems at the facility and all of the problems with the way that they do their tank, their term process, and the way that they simply aren't able to identify where the problems are in these tanks, so they can't address them. And he talked about all of how the risks are really underestimated, and that importantly they're at the end of their useful life. And then we got to the Navy's witnesses, and you heard Secretary Balaki talk about the emergency order. Without the emergency order, the DOH is not going to have a role in telling the Navy how it has to interpret the Secretary's order. And as Mr. Hagan talked to the Secretary about, the Secretary could also suspend that order whenever it wants. So it doesn't address the peril. It doesn't make sure that it's going to be addressed. It leaves it in the Navy's hand. And we talked about with Captain Myers, and he talked about, he recognized that this is a crisis, this is an emergency. He said that, and he talked about the fact that the May 6th release was actually, they thought it was originally hundreds of gallons, and it was really probably 19,000 gallons. And again, this makes us wonder about their systems on systems, about how do they track things, how do they know things, how can we have any
15
confidence?
minutes has elapsed.
Thank you. And he also talked about the tank tightness testing and how they are not actually capable of telling anything about the maintenance of the facilities. And you can look back on Sherry Ing's and Michael McGinnis's testimony, but I think it bears out the situation that we know. The Navy has told us that they've tried. They want to keep the fuel in the tanks. And they want to address a situation when it happens, and they're willing to put some effort into trying to address a situation after it happens. But what this kind of test run has demonstrated, that they can't do it without harming the people. They can't do it without harming the environment. And so we have to ask you, the Department of Health, to take an action today to make sure that this imminent peril doesn't turn into a catastrophe beyond proportions, a catastrophe that we'll never be able to address. We believe that's your constitutional duty, and we ask that you do it. Thank you very much.
Thank you, Ms. Gannon. Deputy Attorney General Hargrove.
Good morning, Hearings Officer Day, parties, council, members of the public. As we barrel towards the season, it's rapidly approaching. I'm reminded of a classic tale whereby a stubborn man is visited upon by his colleague, Jacob Marley, who warns his old friend of imminent peril. Then before the stubborn man appears three ghosts: Christmas past, Christmas present, Christmas yet to be. We heard yesterday evidence of past historical releases, faint memories now, poorly documented, many happening long before environmental laws and regulations were in place. But somehow their presence still haunts us to this day. Their presence is felt in the core samples stained with oil from underneath the Red Hill tanks, the soil vapor, which still detects hot weathering, slowly degrading old fuel. And last but not least, petroleum in our groundwater, some of which has a chemical signature that suggests it was lost long, long ago. There is no way to get that out of the mountain. I suspect it would take more dump trucks than even the Navy could airlift, and I suspect most of the folks that live on Oahu would miss Red Hill if it were to be removed. We can't get it out of the groundwater either. You can't stick a straw and suck it all out. It doesn't work. You heard Phoenix Grange explain why that doesn't work. Historically, it doesn't work. It was once thought to maybe work, but it kind of just doesn't. Then we heard about the present releases, of which there are quite a few, as Mr. Henkin described earlier, 2 in 1 year, not good if you're performing statistical analysis. But do we really know that these are the only ones? Do we know that we would even have found out about this one, but for the fact that kind of everybody in military housing had to stop using their water, which is sort of an inconvenience. Do we know how much was lost? I suspect we don't. I hazard to guess we never will. Does it seem plausible that on May 6th, of the 1,618 gallons of fuel, they recovered 1,580 gallons, leaving only 38 gallons in the environment? Yet we see spikes in the TPH in the groundwater that suggest far greater. Does it seem plausible that on November 20, 14,000 gallons were estimated to have been lost by the Navy, but were miraculously also recovered by the Navy? Yet 100,000 people are still without safe drinking water. None of this makes any sense, which is exactly why you heard Captain Meyer politely concede that the Navy's investigation is a work in progress. I would argue that Red Hill as an underground storage tank system is a work in progress. But this work should not be done at our expense. Like an anvil on a fraying thread hanging above our head, the fuel should not sit on top of our aquifer while the Navy tries to figure out what is going wrong and what it can do to fix it. The Navy can take all the time it wants to fix all the myriad problems we heard about yesterday once the fuel, i.e. imminent threat, is removed. The threat is the fuel, not the Navy's incompetence. The Navy incompetence simply demonstrates how real and present the danger is. These present releases, like ghosts, a genie, if you will, they're out of the bottle, but you can't put them back in. Like the genie in the fables that gets out of the bottle, it causes chaos. Military families scrambling to find clean water to wash their babies, hotels to find room for them during the holidays, no certainty when they'll be able to return to their own homes. The Navy is chasing that genie. Airlifts of water treatment equipment at great expense to the taxpayer, wishing maybe that money had been spent on preventative measures rather than trying to clean water that was, well, it was clean before they poisoned it. Flushing contaminated water, dumping that water all over the land above Pearl Harbor. Then there is the ghost of Christmas future. Future releases that have yet to happen but are almost guaranteed. She ain't getting any younger. Even by the Navy's own estimation, this 80-year-old facility is corroding and it will leak. It doesn't like its contractors that tell the Navy what it doesn't want to hear. They don't agree with the contractors, but nevertheless, that's what the Navy's stuck with. By the Navy's own estimate, chronic releases have a probability of over 5,000 gallons per year. Note that Dr. Norfleet, the Board of Water Supply's witness, strongly suggested, I think his opinion was that it was a gross underestimate of the risk, certainly in light of the more recent ones. And they cannot prevent them. And they will come. There's no cathodic protection, despite the fact that the tanks are in a corrosive environment. The process that the Navy refers to as NDE, this is a non-destructive examination using electromagnetic imaging, has a success rate basically of 60%. I don't think anybody would be happy with the 60. My second grade teacher would have been very frustrated with me, and I would have gotten some letters home if I got 60% of the questions right. Ridiculously behind schedule. I don't think they're even bothering to try and catch up. There's no evidence that the Navy can catch up, even if they want to. Some of these tanks are 38, 40 years without inspection. This does not inspire any confidence in their ability to operate a system. How often do you change the oil in your car? It has to be properly maintained, or you won't expect it to start. And by the way, if your car started 60% of the time, would that be a car you'd keep very long? And there's all this talk about release detection, but this only lets you know the fuel is gone after it's too late, and assuming that it even works. You heard from both Lene Ichinatsubo and Dr. Norfleet that chronic releases in particular can go undetected by most release detection methods. Finally, you heard Ms. Ng continue the Navy's insistence that its groundwater modeling is useful when the Department of Health has repeatedly advised them that they are both ignoring available data, making false assumptions. The Navy has yet to even complete its fate and transport model, the purpose of which is to inform the Navy of the imminent peril it is today continuing to ignore. Again, it doesn't want to know. The Navy does not want to know the truth because the truth makes it incredibly inconvenient for the Navy to continue to operate this facility. They have this magical capture zone that conveniently under the Red Hill tanks will capture the releases, these future releases. They will magically hide without affecting the drinking water. Even if this were true, which the department clearly said in its presentation, this is Phoenix Grange, said clearly it is not true. It's still a ticking time bomb of contamination sitting above the aquifer in a poorly characterized geology. It's in the environment. They're just saying it won't ruin your drinking water. I would not take that bet. The Navy says the geology under Red Hill is like a sponge, that it will hold future releases, yet this conclusion is not scientifically supported. The Navy's estimated holding capacity, 2,600,000 in 2018, revised down to, well, let's just say 66,000 to 112,000 in 2021. I suspect the Navy may want to revisit its estimate of how much can be held in the Red Hill sponge now that we've seen what happens when you have a release right under the tanks of an unknown quantity with a direct pathway to the groundwater. The question for the Navy now is, having seen the ghost of Christmas past, present, and future, why is now not the right time to move the fuel? Why not remove the threat and take the time to figure out what the vulnerabilities are? Why insist stubbornly that the fuel cannot be stored somewhere other than above our aquifer? Dickens didn't write a Christmas story, he wrote a morality tale about how it's never too late to do the right thing. We should not have to wait for the Navy to come to this realization. We don't have to wait for them or for the harm to occur. 342, L 9 envisions action to be taken where there is or will be caused an imminent peril to human health from the operation of a UST system. Let us visit what Mr. Jensen said in his closing. An emergency isn't only what is happening now. I mean, can you imagine if the Department of the Navy was running the Park Service and they had Smokey the Bear saying, instead of only you can prevent forest fires, the slogan was only you can put out forest fires. You have to prevent. You can't wait for the forest to be burned down before you take action. Certainly the Department of Health does not have to wait. And Mr. Jensen creates this false dichotomy that Mr. Hinkin touched upon earlier between the tanks and the piping. You can't have fuel in the piping without fuel in the tanks. There's a large volume of fuel in the tanks, and they're of no use to the Navy unless they get out of the tanks. Best case scenario, they go through secure piping from secure tanks. But what you've heard is they are not. They leak, they're corroding, they can't fix them, they're not even sure where to fix them, and they can't fix them on time. Mr. Jensen and the Navy are using the administrative order on consent. The AOC is covered. We did not know then what we know now, and we certainly were not aware in 2014 that we were facing an imminent peril. That is the difference Mr. Jensen conveniently ignores. The AOC was not addressing an imminent peril. It was addressing a problem that all the parties agreed may be solved over the course of time. We have, through that process, learned a lot more, and then all of a sudden, we see the tracer test this month, end of last month, that the Navy has for many years refused to do. Only not with an innocuous dye that causes no harm, but with fuel, jet fuel. That jet fuel went straight from their tanks to their families' taps. Jensen even acknowledges, Mr. Jensen acknowledges that the EO is a good idea, but as Mr. Hinkin explained quite eloquently, the Navy just doesn't want to do anything other than what it wants to do. It does not want to be ordered to do anything, and it's just refusing to even take its own advice, which is take a breather, figure out what's going on. Just wants to leave the fuel there. That's not safe. That's not a risk that we should be asked to bear. It's really then not a question of whether or not the department can exercise its emergency power in this case, but how rather it could not in this case. So with that, the Department of Health asked the hearings officer respectfully to affirm the emergency order in its entirety. And I would like to thank counsel and the hearings officer for affording us this opportunity to deliver this argument. Thank you very much.
Thank you, counsel. With that, that closes the evidentiary hearing. Is there anything that anyone would like to raise now? The next thing I'm going to address is findings of fact and conclusions of law. Okay. So as of right now, findings of fact and conclusions of law are scheduled to be due, proposed findings of fact from the parties on tomorrow, Wednesday at 3 o'clock. Based upon the, I think, scale of the record and the need for the parties to identify the portions of the record that are germane, and also to present a workable product to the hearings officer to use. And that, I mean, one that is carefully thought out and one that isn't 1,000 pages, but one that is thought out in a way to be manageable. I think that it is appropriate if the due date be pushed one day to the close of business on Thursday. I will just ask each party in turn if they agree or disagree. I understand that this is an emergency situation. I do note that I believe that if I have given a better work product from the council, I will be able to finish my responsibility to issue proposed findings, conclusions of law, and order to the deputy director. And with that stated, Mr. Hargrove, your position? I'm moving it to Thursday, close of business.
With, and just for clarification, close of business would be Hawaii 5 p.m. or
Correct.
4:30 or?
Let's go with 5 p.m. Thursday.
I think that's a perfectly reasonable request for accommodation, and the department has no objection to that.
Ms. Gannon?
The board agrees, and we do believe that we will be able to give you cleaner sites to work from, and there is a voluminous record here, and we do believe that this is an appropriate accommodation, and we hope we can give you a product that helps you be able to make a decision quickly to deal with this emergency situation.
Good, thank you. Mr. Henkin?
The Sierra Club understands why you're suggesting what you suggest. As we mentioned in the status conference related to our motion to intervene, our position has been that the department should have issued an emergency order that was immediately effective, as HRS 342L9A provides, with the contested case to follow. And if the department had followed that procedure, then we would have less concern about delays in getting to what we understand to be a proposed finding of fact conclusions of law, which will go to the deputy director, which will then occasion further delay in finalizing an order. We're hopeful that that order will include a requirement, will preclude the Secretary of the Navy from rescinding his order, because he will then be subject to a department order that under RCRA he is obliged to follow, to continue to take the measures that we are told are being taken, but more importantly, to expeditiously get moving on defueling the tanks. So I guess we have a question for you, Hearings Officer Day, is what is your expectation about when you can get a proposed finding of fact conclusions of law to the deputy director, if we stick with the original deadline or if we push it to the following day, recognizing that Christmas is upon us?
I am happy to answer that. I think that it depends on, one, the quality of the work product that's given to me to be able to utilize. I would expect and would hope to have an order out no later than early next week. And I think that would probably be the same irrespective of if it was Wednesday or Thursday. I think that a case of this importance requires careful consideration of all parties' views.
Okay. Well, we appreciate the opportunity to express our view, and we defer to you regarding what will help you most expeditiously move this along to address the imminent threat that we are all under.
Thank you, Mr. Henkin. Mr. Jensen.
The Department of the Navy appreciates the extra day for purposes of providing the findings of fact and conclusions of law.
And so with that, I will amend the order orally here. The findings of fact, conclusions of law, and proposed order that was formally due at 3 o'clock tomorrow is extended or continued to 5 o'clock Thursday this week. And Ms. Gannon noted, and I think very appropriately, and I'll just emphasize now, that the proposed findings need to have citations. And when I mean citations, I mean to the extent applicable, pin citations to evidence in the record so that I can actually utilize the documents.
And I do have one question about that hearing officer day. We won't have a transcript from the hearing, so you just want us to do timestamp?
Yeah, I think that's the only way we can, from the document in the record. So basically the docket, the official docket that we've sent to you guys, has the version of the transcript, or pardon me, the version of the video that doesn't have, for instance, when we took breaks and stuff like that, that was on the YouTube channel. It only includes the portions that were on the record. And so that would be the document that I would request that the parties use for their timestamps. With respect to the substance of the documents, I think just for this is, and I'm not telling anyone how to do anything. I want anyone to present the findings and conclusions in any way they feel best and most effective for the presentation of their case. Based upon my comments initially about how I am viewing this case or viewing the issues before me, I'm just going to note that I think it would be helpful if there were two analyses presented, one on each of the two emergencies, and I'll use emergencies as shorthand for the imminent peril language that comes from the statute. One that respects the November 20th release and then the aftermath of that. And then the second one addressing the more systemic issue that is alleged in the emergency order. I believe that would be appropriate, given that that's how, in my mind, I am viewing the issues at this time. And again, if you think that I am incorrect in viewing the issues that way, you can also state that in your proposed findings and conclusions and present a different methodology. With that, are there any other questions for the hearings officer before we conclude? Let's start with Mr. Let's start, just go around. Mr. Hargrove?
I have nothing to add. Thank you.
Ms. Gannon?
No further questions.
Mr. Henkin?
There's another deadline, the deadline that you had set for tomorrow at 3 p.m., Wednesday, 3 p.m. for the parties to inform you about duplicate documents, of which there are several in the record. I can anticipate, I just want to sort of clarify among the council and with you, Hearings Officer Day, how we're going to accomplish that. I can, anticipate that there may be some logistical difficulties in getting people to agree. And then for purposes of the citations in the proposed findings, which document do we cite? And I would imagine that every party would like to cite to their own document because they already know the pin sites. So I think we should sort of figure out how that's going to work.
Okay. And what are you suggesting at this time? Are we still working?
Well, I guess my question is, given your instruction for the parties to be, careful about citation to the record and to the pin sites, is it important to identify duplication of documents, or just? I just anticipate that just maybe another issue that kind of takes up people's time, saying it should be N dash, not S dash.
All right. So how about that? Does anyone think that it doesn't matter? That we don't need to do this?
Yes, Navy does.
Okay, I rescind that. Basically, I think I will just try to mentally keep note of what's going on and do my best. I don't want to burden you guys with anything that you think is unnecessary at this time. So no need for that. That's all.
Thank you.
Okay.
Thank you.
Mr. Jensen, anything?
Nothing further, sir. Thank you very much for.
Okay. I'd like to thank Department of Health staff, timekeeper, everybody for their time. Yesterday was quite a marathon. I'd like to thank the council for what I believe was a very professional and illuminating hearing and closing argument. And I look forward to reading your briefs. I believe the only thing left is the Navy has one document or two documents to put into the record. And then once we get the exhibit list, we'll close the exhibits on that. And I look forward to reading your briefs. Thank you very much.
Thank you.
Thank you.